Hello, this is The Skill, that program on the network service of the Nigerian Television Authority that gives you a deep insight into the happenings in our legal world and the justice sector generally. I am Femi Okeowo with the pleasure of welcoming you to the program. Now, while we are still waiting for the Court of Appeal's interpretation of the effect of Section 84, subsection 12, on the people who wish to contest the general elections in 2023 as to the timing of their resignation, those are people who are in the public office, we on The Scale have set out to do an academic discourse of this provision comparing it with the provision of the Constitution which stipulates the time for public officers to resign before contesting any political office. This time, it's Dele Atumbi that has set out on that journey of speaking to legal minds as to what they think this provision of the Electoral Act does, whether it has any bearing with the constitutional provision on the timing of resignation of public officers. We're going to allow you to do an academic thought of these two provisions, and of course, it is the duty of the court to eventually give a final determination and interpretation of these provisions of the law and how they impact on the intentions or ambitions of any public officer seeking public office.
Anyhow, you seek to hear the interpretation of who a civil servant is refers you to the interpretation section in the Constitution of the Federal Republic of Nigeria, 1999, as amended, and Section 318, which is the interpretation section, tells you that a civil servant is a staff of either the presidency or the ministry or the government as a whole. By extension, you take it down to the state government, governor's office, deputy governor's office, and all. Uh, they are the civil servants, they are the career staff and employees of the government. Those are the ones that are called civil servants, and they are career staff. They are not there on the short-term basis. They are there for the long haul. Political appointee is actually more like a politician who is an independent contractor who maintains an office by reason of being appointed by the appointer. The appointer becomes probably the president, the vice president, the governor, the deputy governor, uh, and, and their likes. So they hold that office at the at the pleasure of the appointer, not the state, but the boss that appoints them. And they are not a staff of the government per se. They are staff of the appointer, and they can be there for as long as the appointer wishes. And any day the appointer feels that appointment will be withdrawn or terminated. So be it. So they are more like independent contractors. They are on their own.
This provision, in my humble view, does not extend to somebody appointed to a political office. And I'm not alone in expressing this view. The judiciary, apart from the fact that it is defined by the Constitution, as I mentioned under Section 318, these sections, these provisions have been called to question before the judiciary. And the calls are unanimous, plethora of authorities, that a political appointee is not in the public service of the federation, of the state, of the local government. A classical example was the case of Oji and Ugochukwu. Oyama Ugochukwu. Oji was chief of staff to the governor. He went to participate without resigning. It was said he was alleged not to have resigned from his office. And Ugochukwu, who was the runner-up in the election, dragged him to court and wanted him to be disqualified on that ground. And so the court had to interpret the provision of Section 182, 1G. And the court came to the conclusion that that provision does not extend to or cover anyone occupying political office by way of appointment. It does not cover. And so, when the hullabaloo about conflict between the Constitution and the Electoral Act was raging, I asked myself, prior to the enactment of Section 84:12, was there a legal provision, a statutory provision, governing the resignation from office of a political office holder? And I asked myself, what is the purpose of asking the civil servant to resign in the first place? I surmise, and the authorities have expressed that view, that it was for the purpose of preventing that office holder from abusing his office, using the resources, using the influence of the office to support his own electoral fortune at the detriment of the other aspirants, or at the detriment of the state where the resources of the state are involved, in order to foreclose that abuse. That was why it was said that if you're a civil servant, you're a public servant, you want to participate in an electoral contest, 30 days, you must quit that office so that you don't use it, you don't abuse it, you don't exploit it to the disadvantage of the state or the disadvantage of the opponent. But before the amendment of the Electoral Act, there was no provision governing that of a political appointee. It means that he could sit in that office unless the governor, the president, or the local government chairman otherwise directs. Because he's appointed, you can ask him to go. But there's no legal provision. If he stays in that office to the end, in fact, contest the election while seated there, use the results of the office to contest, he will not have infringed any law because there's no provision of law governing it. I think it was to that extent that the National Assembly, that is empowered under Section 4 of the Constitution to make law for good governance, for security, for whatever purpose, good administration of the country, thought it wise that what is good for the goose is good for the gander. If the public servant should resign 30 days, in fact, more of a political office holder to resign a longer time than a civil servant. Because the prospect of a civil servant abusing his office is minimal when you compare it with a political office holder like a commissioner, like a chief of staff, like a political advisor, and the host of others to abuse their offices. And therefore, it came up with that provision. So, whereas the Constitution governs resignation from office of public servant or public somebody in the service of the public, Section 84 governs a political office holder, somebody appointed to a political office. So the two relate to two different scenarios. Therefore, there is no conflict of any sort. No conflict.
And they have targeted political office holders. The Constitution did not go after political office holders. The Constitution went after career officers, government workers. If you are going to contest, please, can you just leave at least 30 days? But somewhere down the line, as the political process continues to evolve, I'm certain that legislators are aware, because they are all birds of the same feather with the political appointees. They know that being a political appointee and remaining in office while going to their grounds actually is not voting for those people at the Congress or at any primary to determine who is going to be candidate for offices. Their grounds is to be voted for, because it's there. It's to vote or to be voted for. So their ground is to be voted for, because if you are a political appointee and you want to go for an office and you remain in office as a political appointee, be so congested that the Federal High Court would not be able to do any other thing other than primary election matters. And you see those judges, you pity them, because they sit from 9 a.m. to 3 p.m., some far into the evening. And as they are adjourning, and in the course of the sitting, you see them adjourning so many matters to the following day for ruling. So when they leave the courtroom, they go back to their chambers, then they start preparing rulings. The following day, it continues like that. So we cannot continue like this. We cannot. We cause problems for ourselves in Nigeria. And then we turn around and blame the judiciary. The judiciary is slow. The cases take so long in court. And what have you. But by our legislation, we impose a lot of burden on the judiciary. Things that no judiciary system can really sustain is such that we completely cast upon the body, we cast upon our judiciary. But I know that probably the reason for saying that it's only the Federal High Court that our jurisdiction is to try as much as possible to avoid all these incessant problems of having a matter arising in, for instance, in Imo State, and then you have a judge sitting in Taraba State, giving an order that has to do with the matter in Imo State and all this and all that. Yes, I agree to some extent.
That section seeks to cleanse the system, the polity, to eliminate all the confusions that we used to have before now. It even goes further to actually tell you that the court that has jurisdiction on issues of nomination is the Federal High Court. It is no longer High Court of FCT, High Court of State, and Federal High Court. It is not shared anymore. So it is just a provision that is cleansing the polity, So it is straightforward. A civil servant is not supposed to be a politician. If a civil servant wants to be a politician, he would resign.
But my worry is this. First, do we have enough Federal High Courts to cope with the volume of litigation that will come? I'm afraid that we don't. And when the courts are already busy with criminal active matters, with ordinary matters, the Federal High Court has already engaged fully. If you go to their list, you have 30, 40, 50 cases listed before a judge per day. When you now bring in the surge of litigation arising from election matters, you add to it. The only option available, because these election matters are time-bound, is to shut down on other litigants and face, and I think that appears to me not well considered. They should allow the prevailing situation of the State High Court, the FCT High Court, and the Federal High Court to share this body. But that is the law now. Anybody who goes to any other court will have gone to a court without jurisdiction, and that will be the end of the matter.
On the next segment of our program, we're still going to talk to more legal minds, but this time talking about justice dispensation, or indeed delay in justice dispensation in Nigeria. Some of these people talk about how this mechanism of our justice system can be enhanced to ensure that issues before the courts are not delayed. Indeed, some of them also veer into appointments of judges or judicial officers as a way of enhancing justice dispensation. Let's hear the legal minds as they talk to us. How much of a responsibility can we push to our laws as a factor that determines how fast our dispensation of justice is?
I think, speaking for myself, the delayed justice is not a function of the laws. The delayed justice is a function and the problem of the legal profession. As you may have heard, the Honorable President of National Industrial Court, the attitude of lawyers and by extension the attitude of our judicial officers have contributed in no small measure to delay justice in Nigeria when the matter is in court. And I speak that the matter is in court. I'm not talking about the other fundamental factors at the side of the executive when it comes to criminal matters in terms of investigation, in terms of the thoroughness and the compromising nature of some of our security agencies. But when we come to court, take for instance, the Administration of Criminal Justice Act has set out how criminal litigations should be conducted from day to day and so on and so forth. But that law does not implement itself. It requires the cooperation of the judge or the judex and the lawyers to do what the law says it should be done. Do you know that it is easier to get judgments in our court and much more difficult to enforce it? Indeed, I will want to see delayed justice from the post-judgments angle.
Let's talk about that. That is frightening.
When you have a judgment against government or government agencies and you want to enforce, you first of all seek the consent of the Attorney General, either of the state or of the federation, before you can execute judgments against government agency. That provision of law is there. Now, opportunity had been there in time past for the judiciary to pronounce that provision dead, but nobody is ready to do so.
Is it the judge that tells the beneficiary of his judgment to seek for the consent of the attorney?
No, when you go to enforce, for instance, yes, there are various ways of enforcing judgment. For instance, you talk about garnishee proceedings. When you trace government money to central bank, for instance, there are 1,001 order made absolute against Central Bank of Nigeria that the Central Bank of Nigeria is not willing to release that money to judgment creditor, despite order absolute in garnishee proceeding. They are fighting the battle as if they are the judgment creditor. Their duty is to release the money. Then, when you talk about physical enforcement, for instance, if you have a judgment against the Senate of the Federal Republic of Nigeria, you would require the police to go and pick the vehicle of the president of the Senate or the speaker of the House of Representatives
Or even a senator.
or if a senator himself, or you have a judgment against Inspector General of Police. So in Nigeria, for instance, because there are no consequences for disobedience, the police, the security agencies, and big men have become law unto themselves. So these are part of the reasons why you have what I call delayed justice. Delayed justice is not only to get judgment from court, but after judgment, what is the fruits of the judgment?
So let's look forward. Is there any way out?
The way out is, one, we must respect our judicial institution. Two, we must allow our judicial institution to be independent. Three, the judicial institution themselves must avoid conduct that will bring them into total disrepute. Because once you give appearance of impropriety as a judex, then nobody will respect you.
And it has to do even with our attitude as individuals and as nation. The lawyers have their blame. And when you talk of the lawyers having their blame, you have what I would describe as proper tutelage. The orientation, the philosophy, the mindset of the lawyers being trained in Nigeria must change. That is one. It is those lawyers that now becomes judges, and the beat goes on. If a lawyer with a wrong mentality who gets appointed to the bench will also continue. That is. Then also, the society. There are certain things that the society does to judges, even to the system. People criticize, oh, this one is bad, this one, but the clerk of court, who has been assigned to do certain duties, who is not doing it, it does incalculable damage to the system, to the administration of justice. There's so many things to Nigeria and Nigerians. We must change our mindset about certain things, including the justice system. Then you talk about the appointment, the process of appointment, which to me is also key. The process of appointment should be made to be more transparent. You see, in the world now, people are so much interested in the justice system because the world is so intertwined. Commercial activities in one country has effect in another country. And that is the reason why you now have different protocols. The UN is interested, setting standards. You have the Lilongwe principles, you have the Latima House principles, all pointing out to one thing, all pointing to what's one thing. And that is the fact that your justice system, the process of appointment, the process of recruitment of your judges must be transparent. You must have certain standards that judges, the people you appoint as judges must have.
That's the much we have for you on the scale today. We keep looking at issues and digging them up and helping you to understand more of these issues, particularly if you are a person who wants to compare opinions and see how Nigeria can forge forward using the law as a tool. Thank you for being part of the program today. More issues are on the table, and on the scale, we would always look at them and dissect them for the enhancement of our development in Nigeria. We'll see you again.